was awesome.
Hey, good morning on this fatal Friday, folks. It's day 74 of United States versus Joseph Biggs et al., also known as the Proud Boys trial. And yesterday it happened. The defense rested all 5 defendants. Dominic Pizzola finished his testimony, endured a cross-examination that I will not characterize because the trials are proceeding. But suffice it to say that I saw a man cross-examined on the contents of a diary that he'd written to himself that was seized from his home and then read in open public as though his political confessions were evidence of a crime. And it took all that I could do to not walk out of that courtroom. In any case, at the end of the day, the government suggested that it would have no rebuttal case. And indeed, we expect them to come in this, but wanted to think about it overnight. I expect that they'll walk in and promptly rest this morning. We'll tune up the jury instructions, meaning go over the final charge that the judge will read to the jury. In the District of Columbia, it's done a little differently, or at least by this judge. Many, and I'd probably say most judges, read the law that the jury is to apply to the case after they've heard arguments. In this case, Judge Kelly will read the substantive law, that is, that law describing the legal principles that govern a criminal case, concepts like the presumption of innocence, proof beyond a reasonable doubt, and so forth, together with a definition of the crimes charged. And there are 10 felonies in this case. He will read that to jurors before closing arguments. Now, as an advocate, I like that because now the jury knows what it's shooting at, and he's given us permission to use his charge in talking to the jury about what will happen. It's up in the air who's going to be closing for whom. Lots of developments overnight. The day will show how they unfold, and let's see what happens. It's expected that the government's closing, in other words, the government gives 2 arguments. It opens and then it rebuts what the defense has to say. Judge Kelly has not imposed time limits on any party. The government announced that it intends to argue for 2.5 hours. Good luck with that. I mean, maybe some of the jurors will just say, enough, no mas. Or maybe they'll say, this is so interesting, please talk for another 5. The defendants each were asked to estimate the amount of time that they will spend on closing, and estimates range from an hour to an hour and a half. So do the math, listen to the charge from the judge. Closing arguments will take all day today, probably all day Tuesday, and could potentially spill all day Monday rather, and could potentially spill into Tuesday.
Norm, I'm interested in just from an academic perspective, I reckon for now, the scale of closing arguments is something that I think I don't necessarily understand. An hour and a half for closing remarks seems really long. Why?
Well, Clarence Darrow would say that's just the twinkling of an eye, young man. Clarence Darrow, when he gave closing arguments in the Leopold and Loeb case, and that was a court trial, is reported to have spoken for 9 to 12 hours. Now, if you think about the Proud Boys case, we are entering the 5th month of proceedings today. Jury selection actually began or yesterday, I guess we did. Yeah, jury selection began on December 19th. The jury has heard probably 61 days of evidence in one form or another. And so summarizing all,
imagine 2 months as a juror, like just putting yourself in that position.
Well, more than that, actually, the jury began to sit as a group on January 13th. It took a while to pick the jury and get through all the preliminary hoo-ha. Many courts around the country impose a time limit. You get an hour. Judge Kelly is still relatively new to trying cases as a trier of fact, meaning as a judge. And I think his view is the parties are the best judge of their own advocacy. And a person who runs too long runs the risk of turning jurors off. So he's not imposed time limits. So my view is an hour and a half doesn't seem like a long time. 2.5 does. But, when you consider that the trial transcript, we're probably in the 18 or 19,000 pages of trial transcript right now. There's a lot there. And the government has a highly circumstantial case, in my view, not a strong case. And I think it's entitled to the time it takes to stitch together the variant pieces into the tapestry that it hopes will prove a conviction. From the defense perspective, you choose your theme and you argue it. I think no defendant estimated a closing of more than an hour and a half. And, that's do the math, 7.5 hours of closing, 2.5 from the government, maybe an hour of rebuttal. That's 11 or 12 hours of argument after a jury charge. So it's 2 or 3 days. I think by the time we're done, this jury's going to be running for the door saying, we heard enough. No mas, please. And we're hoping that the last words we hear them say are not guilty, but we'll find out. On that topic, it doesn't look like Alec Baldwin.
Well, before we go, I think Thinking Man has a decent question I want to ask you, and forgive me, Thinking Man, for that sounding condescending. I didn't mean for it to. After a trial like this, how much time off does Norm need before taking on the next big case?
How much time off does Norm need versus how much time off does Norm
really get?
Yeah. The fact of the matter is that last year about this time, things were heating up in the Alex Jones case, and I went to trial in that case and fell right into this case. Now I will leave here, the sooner the better. Try to take a week off, but I've got an appellate brief to get done in the Alex Jones defamation case, and it's currently due on May 26th, and that's 3 big boxes of trial transcripts. When that is over in June, I have a rape trial. July, I'm hoping to take some time off with my family. August, a murder trial. And then I'm supposed to be back down here in September for another January 6th trial. So if you don't find trial relaxing, don't do it. Because if you're a trial lawyer, you go from one to the other. And time off is what you get when you're dead. So,
Understood. Well, I mean, I think that provides plenty of perspective for someone like me. I tend to ramp up. I don't know how sustainable it would be, but I think that it's all about technique, right?
It's about pacing. I mean, it's about me eating right, getting enough rest. I haven't gotten as much exercise as I should. In this case, I've just been, and I am tired right now. I mean, after 4 months of carrying this around, I don't have any trouble sleeping, and for a long time. But the point is that if you know your case and you know the law, how hard can trial really be? You know where you want to get. You have an adversary who's determined not to let you get there, and then it's a battle of wits on a question-by-question basis. So if you like word games or you like competitive sports, and if you love both, trial is pure pleasure. And as opposed to being in the office where you are the recipient of phone calls from any of a number of directions and the personnel crises of your employees and whatnot, trial gives you an excuse to think about one thing and one thing only. And in a complicated case like the Proud Boys case, it's this vast puzzle of historic interest. What did happen on January 6th?
I've been asking myself that, having to pan in and out of what comes across in the flood of our social media feeds, and then talking to you every day. There's this interesting zoom in, zoom out feature. And I think that question is really what I'm left with at the end of all of this.
Well, I think that once a verdict is returned, and I don't have to worry about the breaking the rules of professional conduct involving prejudicial or extrajudicial prejudicial comments. I'd love to talk about that. Maybe we'll engage in a series of discussions on the podcast and take questions, because I think I don't want to sound vain, but I think I now have developed a unique perspective on that trial and on the guys, at least the leadership of the Proud Boys, having sat with them for 4+ months. And I think that what I learned at the trial will surprise a lot of people. So I'm looking forward to sharing that.
Awesome.
As to time off, maybe a weekend, Thinking Man, my more if my wife gets her way, but she's a long-suffering saint who puts up with an awful lot from me.
She's still with you there in DC, or did she head back?
No, she's still with me here in DC. Not sure what she's doing right now. Probably listening to NPR or something that nourishes the soul, as opposed to her jitterbugs of a husband. So let's talk about Alec Baldwin. No trial for Alec. I'm a little surprised by that. I mean, you'll recall Alec Baldwin was on the seat of a film his production company was making called Rust when he was handed a weapon. And as he posed with the weapon discharged, killing one person and seriously injuring another. Question: what was a live round doing in that gun? Uh, Other question: what was that gun doing in Baldwin's hand? Fundamental question: what was Baldwin doing with the gun? And so,
well, even backing up further, recall that he made public statements saying that he didn't pull the trigger, and then there's obviously video evidence that says something different than that. And I want to make sure that we don't bury the lead here, Norm. What I've got on the screen is an update as of yesterday late afternoon. So all this stuff broke. This actually came through. Actually, excuse me, this morning, or maybe I guess early in the morning. This
well,
kind of
what are the new facts? Because I mean, on the old facts,
that's the issue. So here we have the quote from the Santa Fe District Attorney. Quote, over the last few days and in preparation for the May 3rd, 2023 preliminary hearing, new facts were revealed that demand further investigation and forensic analysis in the case against Alexander Alec Ray Baldwin III. Consequently, we cannot proceed under the current time constraints and on the facts and evidence turned over by law enforcement in its existing form. We therefore will be dismissing the involuntary manslaughter charges against Mr. Baldwin to conduct further investigation. This decision does not absolve Mr. Baldwin of criminal culpability and charges may be refiled. Our follow-up investigation will remain active and ongoing.
All right, so it's not quite the victory that it looks like. It may be, no pun intended, to Mr. Baldwin. It may be that he's dodged this bullet for the time being. So in New Mexico, I gather, there is a timeline for preliminary hearings to determine whether the evidence is sufficient to warrant going to trial. And if a defendant doesn't waive these, the state is required to put its case, or at least is required to meet the burden required at an evidentiary hearing. I don't know what new forensic evidence could possibly derail the case. My view is, if you find yourself with a gun in your hand and you point that gun at someone and the gun goes off and kills them, you've got some splaining to do. And at a bare minimum, that makes out a case for criminally negligent homicide.
Well, Norm, I don't want this to be difficult for people listening or watching, but this is something I know a little about just because of my upbringing. Both of my parents were in law enforcement. I was raised around firearms. I'm well attuned to what safety protocols and habits should be formed, good habits, and how to treat firearms. Consequently, I also know, just really through my mother's work, that when you lead or manage people who have firearms, there will be what are known as accidental discharges. And the most common thing I heard in my household growing up when it came to these things was that whomever's firearm discharged accidentally, without fail, they would say, "I don't know what happened. It just went off," right? And as an immediate reaction to, I guess, assuage scrutiny, so that they didn't do it. Something was wrong with the firearm. But anybody who knows firearms, specifically handguns, knows that the manufacturing specs on these things have to be perfect. The reality is there is a next to zero, as close to zero chance as you can possibly get in this life, probability that a firearm will just sit there and discharge on its own. It doesn't happen. And I think that if there is forensic analysis that needs to be done, there is something to do with Alec alleging that the firearm may have just discharged on its own. And I heard reference to this on a couple of different podcasts. I haven't been able to recreate that with any of the sources that we have. But barring that, Norm, and I just bring that because it's sort of the Occam's razor thing, right? What is the simplest reason for something that is as vague as this? In my world, it would just be Alec alleging, and then the prosecution not being able to stand on its own to say, okay, whether you meant to or not, we have the burden of showing that this specific firearm needs to go under forensic testing. We need to send it to the manufacturer. They need to give us a report back, and we couldn't have that report done by the time we were supposed to make preliminary statements.
So that could be bad news for Mr. Baldwin, because
Absolutely.
he has claimed that he didn't pull the trigger. It's reported that an FBI forensic analysis said that the gun could not have discharged unless he did. Now, if there is some sort of design defect in the gun in general, I haven't heard about that. If there's a manufacturing defect in this particular gun warranting further analysis, fine. But from my perspective, that still begs the larger question. If you've got a gun in your hand and you point it to someone, it seems to me that the reasonable person expects the pointer to be sure that there's nothing in it. And so I wouldn't dream of pointing a gun in the direction of another person unless I was satisfied
That's
that
rule
there was
number one.
not a
Treat
live
every gun
round in
like
it.
it's loaded. Well,
And so from that perspective, even though I'm a criminal defense lawyer, I'm not happy. I'm sort of outraged, actually, by the decision not to proceed. And I suspect we need to take seriously the prosecution's claim that further analysis will take place.
well, and then this is only going to further infuriate you. Despite reports earlier in the day that former Rust armorer Hannah Gutierrez Reed would also see her charges dropped, her status has not changed. Charges against Hannah Gutierrez Reed remain unchanged, the prosecutor said.
When I read that initially, I wondered if Baldwin, paid his way out of the case, but I see that he's still fighting the civil suit against.
I thought I thought the civil suit, at least with the estate, was done back in October, and we can check on that. Maybe I'm thinking of something.
One of the story you sent me overnight suggested that Baldwin is still trying to get it dismissed, so we should look at that.
Okay.
So we'll be following that. If anybody gets any information on these forensic tests, I'd like to know it. One way that this plays out is that the prosecution thought it could only prove the lesser form of manslaughter, negligent homicide, that it's looking for information to charge a little higher. And for those of you saying, well, wait a minute, what about double jeopardy? Here's a little mini law school lesson for you law nerds. Jeopardy, what is double jeopardy? Under the Fifth Amendment to the United States Constitution, you can't be charged for the same crime twice. Most states have a double jeopardy clause in their state constitutions. Jeopardy doesn't attach, meaning the criminal case against you doesn't count for double jeopardy purposes until your jury is sworn. So what New Mexico has done by dropping the case at this point is saying we can't make the timelines. There are questions we need to investigate. Therefore, we need more time. So if the charge is dropped right now and dismissed, as long as it's not dismissed with prejudice, meaning such that it cannot be revived, nothing would prevent New Mexico from bringing the case again and but the only limitation is they'd have to bring it within the statute of limitations. And for misdemeanor manslaughter, for example, Connecticut has a statute called criminally negligent homicide. Misdemeanor statutes of limitations are usually pretty quick. So there's going to be a race against the clock. I'm not sure what happened here. The New Mexico District Attorney's Office is being a little tight-lipped. We'll keep an eye on it. It all makes me wonder, whether somebody in the New Mexico District Attorney's Office is needing to go to confession and talk to their priest about a botched investigation, or what Alex Jones may have said to a priest in a confessional. Why do I bring that up? Washington State is considering a bill to eliminate the priest penitent privilege. As you know from listening to this show regularly, a privilege is a situation where something will be beyond the reach of the law. If you think of life as a board game, Monopoly, if you will, the rule of law describes the moves that can be made. The roll of dice motivates life chances, and these pieces move around according to the rules and act with respect to one another in the rules of the game. That's the rule of law. A privilege takes a piece off the board and says you can't play with it. And thus, when you ask your lawyer for advice, those conversations are privileged, and no one can be compelled to testify about them, unless, of course, as we've seen, in the grand jury investigation of Donald Trump, where lawyers have been compelled to testify, unless a court is persuaded that your legal services were used in the service of a crime or a fraud. So it's not an absolute privilege; it's a qualified privilege, the attorney-client privilege, and it can be penetrated. The priest-penitent relationship has traditionally been regarded in the law as an absolute privilege. And under canon law, that is the law that governs the Catholic Church, it is such a big deal. It's one of the seven sacraments confession. It's such a big deal that a priest who violates it faces immediate excommunication. He's removed from the church. Washington State takes the position that that in the context of abuse of children, mandated reporters should include priests. Now, mandated reporters include teachers, typically social workers, or others who are in a position wherein a child would regard them as in a position of authority or trust. And if they learn that a child has suspected, they come to suspect that the child's been subject to abuse, they are mandated or required to report that abuse to child welfare people. So in Washington, the legislature is considering legislation to require priests to do likewise, and that would transform an absolute privilege into a qualified privilege. And to my mind, it's a sort of shocking assertion of state power, and is likely to yield First Amendment challenges. And let's talk about the First Amendment for a minute, because the First Amendment, we all know, guarantees freedom of religion, but it also avoids establishment of religion. So there's a negative and a positive aspect. You're free to believe. You can't be what you like. The government can't endorse a particular set of beliefs. And so, the priest-penitent relationship is a common law or statutory privilege. It's not constitutional. And states arguably are able to tinker with it at their will. But if they tinker with it and eliminate the priest-penitent privilege, are they abridging a person's freedom of religion? If you're a Catholic and one of the sacraments that you have is the ability to go to confession and get yourself right with God, and the church's rules require that they be confidential, can the state really countermand those rules without infringing on the establishment of religion? On the other hand, and this is what makes the law so great, if you're the child welfare agency, couldn't you say that an endorsement of the privilege is basically an establishment of a religious privilege that no one else will enjoy? So I set myself up as the high priest of the Holy Church of Law and Legitimacy, the second person of the Trinity, Mike Boyer being one, and I set up a 1-800 confession line. You tell me your dirty secrets, and then I'm brought into court. There's no privilege there. We're not your lawyers, we're not your priests, we're nothing, and so we're compelled to testify or undergo the pains that a reluctant witness does. If we are members of the Catholic Church, however, that same refusal traditionally is honored by the courts. If the courts are required to honor it, are they establishing a religious privilege that Mike and I don't enjoy when we hear your confession? So I think that the legislation of this kind and the litigation that accompanies it reflect a growing secularization in our society. There was a time when no one would dream of trying to undermine the priest-penitent relationship. But now a legislature, in the name of child welfare, not only dreams of it, but proposes it. And, one wonders, whether this same legislature is going to be passing legislation to protect trans story hours. And, you marvel at a society in which traditional religious institutions are under attack and new forms of expressive individualism are glorified almost without thinking. So,
well, and the interesting part about this, so for the procedural posture, there was this bill, Senate Bill 5280, was originally passed with the language that I have on the screen for you, Norm. And then it was sent to the House. What the House returned was a version of the bill without the exception that I have provided here on the screen, and actually provided for jail time for the clergy members that didn't violate the confession, the canon of confession, or the seal of confession rather. And so I think that the Senate has rejected those amendments, and now it is up to the House to decide whether they are going to go forth with passing this bill as is, with the exception, or whether they're going to make this an issue. The background of the bill itself is about report for child abuse. And when I was reading through this, I was just thinking to myself, because you've got, any member of the general public, nonprofit corporation, for-profit corporation, anybody within government, anybody in a school system, anybody. It just makes everybody some sort of snitch. There's like a snitching obligation inherent in this. And the other thing is it relies on the subjective interpretation of somebody who reasonably suspects there to be child abuse. And so I'm not so certain that this is even tailored in a way that is going to provide any sort of practical benefit or is actually going to neutralize or mitigate any sort of systemic problem of child abuse within the state of Washington. And I would need to read the bill even further or understand how this is going to be funded to see if there's even any real issue that this portends to solve. And with that as the backdrop, this in particular, why this sub issue has become really what's making news is, to your point, kind of disconcerting, right?
Yeah, no, it is very disconcerting. But let me give you a little background on how these things work, because I practice primarily in Connecticut when I'm not chasing whatever it is that's led me to chase cases out of state. Misguided sense of notoriety, I suppose. But in Connecticut, the mandated reported statute applies to social workers. And so it is not uncommon to see a social worker charged with failing to report. And so I've represented social workers who were presented by their patients, I guess you'd say, with a child or a vulnerable person who made ambiguous noises, utterances about whether they had been abused. And in one case, flat out declared that they had. But the social worker made a judgment that disclosing that abuse would cause more harm to the child than not. So, for example, father, I don't want to make the examples are all bizarre, but and so in one case we tried to defend a social worker on the grounds that her clinical judgment about the welfare of the child she was treating superseded the statute, and she had a right to make that. And we had to compromise the case out. The person lost their license for a while, and the consequences were dire. So I think that what this law is intended to do is broaden the net of those who have access to information about vulnerable children in order to protect those children from further or continued abuse. And I don't think that's a bad law. So I don't think it makes us into a universe of snitches. What it says is if you've got insight, you should use it in a responsible way for the benefit of the child. I think in the priest penitent thing interests me on strict First Amendment grounds. And that is, I don't favor a state with total control or total power. While I do believe there's an objective universe and there is a best answer into how we can all live together, I don't want the state administering it. And I'd rather tolerate the errors and inconveniences of individuals fighting it out for themselves rather than living in a managed society or a public health state. And so this seems to be an effort by the state to overreach and to interfere and to overstep a limit. And if it can do this here, it can do it elsewhere.
Well, and I don't know the history of the Catholic Church on this particular issue.
Pete Atkinson, where are you?
Yeah, he's not. He hasn't. I don't think that he's in the chat this morning. But one question I have is how backward facing is this reporting requirement? So if we think about the nature of confession, right? It is an intimate, trusting relationship guarded by the ethical principles that mirror that of the attorney-client privilege norm. And what I was just thinking about is, are we concerned about ongoing child abuse or is this a dragnet for anybody who perhaps comes to a priest and represents something abstractly in the past that could be interpreted subjectively to be a credible oral report of child abuse?
Yeah, it's probably both. And as to the privilege, I mean, the attorney-client privilege, one of the lawyers know this. One of the difficulties in managing it is that confession may be good for the soul, but I'm not a curator of your soul. I protect your bodily prospects. And so the attorney-client privilege has a utilitarian function for a lawyer, and that is it's intended to lower the barrier of communication between lawyers and clients, such that lawyers can get all the information they need to adequately defend a person. People come to law offices feeling that if they confess, their lawyers won't like them and won't do their job.
Yeah,
now,
that's right.
when you go to a priest, there's no worldly utilitarian consideration. Presumably, you come out of some deep sense of vocation or belief that this priest has access to God and forgiveness and righteousness in your soul and so forth. And there's nothing utilitarian about that at all. And to compress that relationship into the dismal calculus of what's good for society seems to place too much of a role on society and to empower the states in ways that are inconsistent with, in my view, the Bill of Rights and the fundamental commitment we made to giving people a sense of liberty and efficacy in their own skins. But I digress. And we never got to the Biden administration's that. Did you know that if you have a good credit score, you'll soon potentially be paying more on your mortgage to subsidize people who don't? And how does that make you feel? And did you know that at the same time that federal regulators are imposing this new regulation, it'll go into effect on May 1st, the Senate is considering a bill that would require a digital identification card. And if you begin to connect these dots and you start to think, wait a minute, what's going on? I'm being managed and required to pay more because of who I am. Who's going to keep track of all that? Welcome to Digitopia, folks. It's happening. Social utility scoring is right around the corner, and you're going to be manipulated, charged more or less for services, depending on who you are and who the masters of the algorithm decide should benefit. And if you're not and this is consistent in a way with the theme about trying to undermine the priest-penitent relationship, some vision of the collective good is going to be made mandatory in your day-to-day transactions, in your credit card, and perhaps in your day-to-day relationships with your priest or pastor. So frightening world. And I just want one last note to round out, Mike. Similar efforts in Washington to the priest-penitent thing failed recently in Delaware and Vermont. But this appears to be a movement that's gathering momentum, and it's something to keep an eye on.
Well, it's just a derivative of the movement that we've seen in larger secular society, where the government has taken the place of the divine in most young people's lives. And I think that these sorts of things are going to be very difficult to combat on grounds that connect with on grounds that can occupy a bridge between a generation that was and the generation forthcoming. So these are really interesting topics.
As Generation Zombie thumps its chest and says, beware of us in the polling place, I'm saying, yeah, I am. I'm just hoping around enough of you to overrun the Bill of Rights, and I've got my doubts. But hey, we've talked our way through another half an hour of your life and another week of your lives. Thank you for listening, folks. We will be back next week. Hopefully I'll be back in Connecticut soon, or in Vermont, but at least out of Washington, D.C. And just for old time's sake, Mike, I'm getting ready to leave the room. I object.
Overruled.
I feel right at home. Thanks for listening to Law and Legitimacy.
Thank you. And you can find us on Rumble. Obviously, please give us a subscribe and thumbs up on this video. For those who are audio only, you can find us on Apple Podcasts, Spotify, Google Play, Overcast, etc. right after the stream is over. Please consider becoming a Locals subscriber and member. Norm, now that he is out of the lion's den and leaving the swamp, we will be connecting on ways to embolden what we're doing, expand the offering. I've gotten several notes via email from some of you who watch daily. We very much appreciate you. And I think what I've articulated in a couple of those emails is that, we've got 30 minutes. The key is consistency, reliability, and making sure that we get our reps in. But as soon as we are able to begin doing some more stuff, getting guests on, longer form interviews, I know that, Norm, you're ready to get back to some of those more philosophical meanderings, as I think you've referred to it before. And I certainly am as well. So thank you all for being here. Let's see. Good luck comes from Rachel Perry Goff.
The government needs it. I don't.
Anyway, I'll let you go, Norm.
All right,
thank you, everybody. See you later.